Yeah, hello and welcome back to the channel. This is again the lecture on international taxation basics. And before we go on to a new chapter, let me sum up a bit, or let me show you a bit how you can use that knowledge to solve cases. Just a short one only. Well, how to proceed? You first begin always with determining the residence of the taxpayer or the taxpayers in question. That is the article which corresponds to Article 4 of the OECD Model Convention. Later you go on to examining the events which happen in the case. And for each event, you pose two questions. The first question is, can the source state where the money comes from, or more generally, the state where you are not residents, can that state tax the event in question? For this, and only for this question, you have to see to the articles which correspond to 6 to 21 of the OECD Model Convention. And if you have to do with a concrete double taxation treaty between two countries, you should always keep in mind it may be that the treaty is accompanied by a protocol, and that protocol might modify, revoke, clarify, or so certain rules contained in the main articles. And so you should always then have a look into the protocol. If the protocol changes your impression of what the articles in the first part say. The second question is, if the source state can levy a tax, how must the state of residence react in order to avoid a double taxation? This is what corresponds to the Articles 23A or B of the OECD Model Convention. And again, here the hint: if there is a protocol, don't forget to have a look at it. It might clarify, modify, revoke, or change the contents of the main article in the text with respect to certain situations or certain constellations. Well, so that is what we have to keep in mind as a testing scheme. And I decided that we use for the three cases which I'm going to speak about the double taxation treaty Germany-UK for simple reasons. There we have an official English version. It's a legal text, so it's free of any copyright, and so we just can use it without any problems. Well, so let's have a look. A lives in Cologne in Germany, but he has a second home in Vienna in Austria. However, to be examined is the treatment under the double taxation treaty Germany-UK. Among others, A has income from the following sources. He gets rental income from a house in London. He has received a dividend from a limited company in London, and he received a dividend from a company which is established as a British limited but has its place of management and all its economic activities in Germany. So we have a case that A lives in Cologne. So that should normally indicate a place of residence in Germany under Article 4.1. Is resident in Germany. See Article 4.1 of the OECD Model Convention. And there is a second home in Vienna. Now, you know there are certain rules on double residence, so-called tiebreaker rules, but they only apply if the taxpayer has residence in both contracting states. And as this task is about the relation between Germany and the UK, the taxpayer has a residence only in one of the two countries, so Article 4.1 would already be enough. However, we have to check if 4.1 of the OECD model is really and actually 4.1 of the UK treaty, and if it has the same wording and meaning. So let's have a short look there. So here it is, the UK treaty, Article 4. A resident. For the purposes of this convention, the term resident of contracting state means any person who, under the laws of that state, is liable to tax therein by reason of his domicile, residence, place of management, and so on. And that would mean, yes, our German taxpayer is resident in Germany. And paragraph 2 of Article 4 applies only in the case if somebody is resident of both contracting states, and that's here not the case. So indeed, we have found out what we already suspected. The UK treaty has in Article 4 the same contents as the OECD model, so we can be confident and happy that it's exactly as we expected. So it's Article 4.1 of the DTT Germany UK. And now let's go to number 2, the events. 2.1, the rental income from London. Our first question must be A, what can or may the UK do as the state which is not the state of residence? Our presumption, assumption, supposition, suspicion will be that it is Article 6, probably, 6.1, because that's the OECD Model Convention article, and it would say that this rent can be taxed where the house is located so that the UK can take a tax. That's our suspicion. UK can levy a tax on the rental income, and we suppose it's Article 6.1. However, again, we are going to check this if that is not only our idea, but also really taken over from the OECD Model Convention into the British Treaty, and if we can really find it at the same place with the same words. So let's have a look. Okay, let's have a look. Article 6, income derived by a resident of a contracting state. So let's directly fit in or fill in income received by a resident of Germany from immovable property which is located in England, UK, may be taxed in England, UK. So that's a clear answer. It's identical to what the OECD model says. It stands at the same point and place. The only thing we should check is if the protocol to the treaty modifies that in any way. So let's have a short look on that. So here's that protocol, and the protocol begins with statements with reference to Article 10, dividends, 10 and 11, 10, 11 and 12, and 27, and so, and 29. So no statement which modifies the contents of Article 6. So that seems to be complete without any problem. That's perfect. That's nice. So we know what we found out about Article 6. That is correct and can be written down. So Article 6.1 of the DTT Germany UK. And our next question will then be, how must Germany react to avoid a double taxation? And we suspect that this should be Article 23 in the A variant probably, but we will have to look that up in the treaty itself. So let's have a look to Article 23 or what corresponds to that in the British Treaty. Let's have a look here. Article 23, and you know that in concrete DTTs there is no an A and B variant, but there you have one paragraph for the residents of, let's say, Germany, and the second paragraph which states what the UK is going to do for its residents to avoid the double taxation. Here you find the residents of Germany treated in the first paragraph of the treaty. So unless foreign tax credit is to be allowed under paragraph B, subparagraph B, there shall be exempted the income from the assessment basis of the German tax, which is effectively taxed in the UK. So there is an important condition here. The exemption by Germany is only granted if there is an effective taxation in the UK, so that that only happens in cases where the tax in the UK is in the law, is actually assessed and collected. Then there is some special reference to dividends. And now we get the exemptions, or no, the exceptions where the exemption does not take place. Subparagraph B, subject to the provisions of German tax law, blah blah, and so on. A credit instead of an exemption is granted for dividends, items of income that may be taxed in the UK according to paragraph 2 of Article 13, certain capital gains, so directors' fees, and items of income under Article 16, artists and sportsmen, and so doesn't apply. Then we have a letter C, which says the provisions of subparagraph B shall apply instead of the provisions of subparagraph A, so credit methods shall apply instead of exemption methods. 2, items of income as defined in Articles 7 and 10. If the resident of Germany does not prove that the gross income of the permanent establishment in the business year in which the profit has been realized and so on was derived exclusively or almost exclusively from activities within the meaning of paragraph 1, section 8, Außensteuergesetz, blah blah and so on, does not really apply here because we have neither Article 7 nor 10, we have Article 6. However, then we have an E clause, letter E. In contrast to the provisions of subparagraph A, notwithstanding the provisions, double taxation shall be avoided by allowing a tax credit as laid down in subparagraph B. If the contracting state's items of income or capital are placed under different provisions of this convention or attributed to different persons, and this is a conflict, or if after due consultation with the competent authorities of the UK, Germany notifies the UK that it wants to apply the provisions of subparagraph B to other instances. So that would be a so-called switch-over clause. Nothing of that changes the first subparagraph, letter A here, that there will be an exemption as we expected. So we can sum that up. That's evidently what's coming out here. So here we have Article 23, 1, letter A, TTT, Germany, UK. Germany must, better here, must exempt the rent from the German income tax. Okay, 2.2. Dividend from a limited company in the UK. Letter A is again, may the UK levy a tax. And for this, we would expect that we find a solution in Article 10 of the OECD model, and so probably our first guess, it will probably also be Article 10 in the British Treaty. Let's have a look. Here we have in Article 10 indeed what we expected, dividends. 10.1 says what is already clear also without its existence, it's a mere clarification. Dividends paid by a company which is resident of a contracting state to a resident of the other contracting state may be taxed in that other case. Let's fill in and check it if it really applies. We have a British company, so it's resident in the UK, and it pays a dividend to a recipient in the other state in Germany, so 10.1 applies. They can be taxed in Germany. Whatever comes next, that is not affected by that. However, 10.2, such dividends may also be taxed in the UK. But then we have an upper limit. It's either 5% if the recipient is a company which holds at least 10%. That's not our case, so let's forget about that. Or 10% of the gross amount of the dividends if the beneficial is a pension scheme. That's also not our case. Or 15% of the gross income in all other states, in all other cases. That is evidently our case. So we can sum up. Germany may tax, however, the British can also take 15%. However, sorry, again, and however, life is complicated. Well, however, we will have to check the protocol if something what is said here is perhaps modified. And here we have the protocol. There is indeed a declaration or clarification or statement to reference to Article 10, but it just says what a pension scheme is. That's not relevant for our case. That's very nice. And another reference is to 10 and 11. Notwithstanding the provisions of 10 and 11, so in contrast to the provisions of 10 and 11 of this convention, dividends and interest may be taxed in the states where they arise if they are derived from rights or debts carrying a right to participate in profits, so-called silent partnership or partiarisches Darlehen in Germany or something like that. And under the condition that they lead to a business expense in the country where they are paid. That also does not come into play here. And there is a next statement concerning dividends, interest, and royalties. That's a clause for a three-state constellation, which is also not relevant here. So very nice. The basic rules remain applicable. So that was 10.1, Germany may tax, and 10.2, the British can take a tax of 15%, letter C in 10.2. Let's put it on paper. Article 10.1 of the DTT, Germany, UK. Germany may tax the dividend irrespective of what comes next, but also 10.2, letter C, surprisingly, of Germany, UK, but also UK may tax with an upper limit of 15%. Now we need the reaction which Germany needs to take, because GB can take a tax. So what must Germany do in order to avoid double taxation? That is probably again Article 23. It was paragraph 1 there, and we will have to have a look. So here we have Article 23, paragraph 1, subparagraph B, subject to the provisions of German tax law regarding the credit for foreign tax that alludes to paragraph 34C and its rules for the credit tax limit. There shall be allowed as a credit against German tax payable in the respect of the following items, blah, blah, dividends, but dividends not dealt with in subparagraph A. So we have to check which dividends are mentioned in letter A. and that is dividends which are paid to a parent company which holds at least 10%. That is not our case here because we don't have a parent company. So we have credit method is applied under 23.1, letter B, subletter AA. So letter A, no, letter B, subletter AA. Germany must apply the credit method to the dividend income. Okay, so that was this item. And now we come to 2.3, the dividend received from a company which is registered as UK Limited but has place of management and all activities in Germany. So, may the UK levy the tax? In that case, the first question we have to ask is Article 10, does it apply? And Article 10, as you remember, is for cross-border dividend payments. That is for payments from a UK limited or UK company to a German recipient. Now, this company is resident under tax law in the UK and in Germany, and so it's a case where we have to look to Article 4. Is it for the DTT a company resident in the UK or in Germany? And that, ladies and gentlemen, we will have to look up in the text again. So here we have Article 4, and for one says that the company is resident in the UK because it has its registration there, and for one also says it's resident in Germany because the place of management is there. So we have a case of double residency, and the conflict is solved by the rule in subparagraph or paragraph 3, where by reason of the provision of paragraph 1, a person other than an individual is a resident of both states, so of Germany and the UK, then only the place of effective management counts. That is in Germany. So we have a German company here, and that leads to the conclusion that Article 10 does not apply. In those cases, you remember that in those cases, Article 21 takes effect. So let's look up this. 21. Where is 21? Let us look and find Article 21. If Article 21 is really Article 21 in the British Treaty, that has to be found out by scrolling, and there we have other income. Items of income beneficially owned by a resident of a contracting state wherever arising, which are not dealt with in the foregoing articles, shall only be taxable in that state, so in the country of residence. Yeah, that clarifies matters. So we have a German company which pays dividends to German. Article 10 does not apply. Article 21 applies and gives the only right to tax to Germany. So under 4.3 DTT Germany UK, it is a German resident company. So Article 10, 1 and 2 do not apply to this case. So Article 21.1, only Germany may levy tax on this dividend. Obligations of Germany, none, because there is no risk of double taxation. So that was everything. Case finished. And Let's have a look to the next case. So, next case. B lives in London, UK, but also has a second residence in Hanover, Germany. And B's family lives with him in London, and there are most of his private friendships and contacts. B is employed by a firm in London, but has been sent only temporarily for a period of 18 months to Germany. That is the reason why he has established that second residence at Hanover. Um, Job income from the activities in employers' offices in Hanover are to be checked, and he has some income from royalties which a publishing house in Germany pays to B for rights in a book which B wrote years ago while he stayed in Italy. That's the whole case, and let's think about a solution. So, the first part of our case will be again the residence, and B has a residence, in the UK, London. Article 4.1 of the DTT Germany UK. You remember still that that applied. And also a residence in Germany, because he is also subjected to unlimited tax liability in Germany, also under 4.1. So we have to check the tiebreaker rule, and for natural persons that should be 4.2, at least in the OECD model. However, we will have to check if that's also for paragraph 2 in the British treaty and what it says. Let's have a look. Here it is for 142, where by reason of the provisions of the first paragraph, an individual is a resident of both states, as in our case here, then his status shall be determined as follows. He shall be deemed to be resident only of the contracting state in which he has a permanent home. That is here in both states. If he has a permanent home in both states, it shall be deemed to be resident only of the contracting state with which these personal economic relations are closer. The personal relations are evidently London, and I would say here he's only temporarily sent to Germany. His main job is before and afterwards still in the UK. So the relations to the UK are also stronger under the economic aspects, and so he will be resident in the UK under 4.2 letter A. So according to Article 4.2a DTT Germany UK, he is resident only in the UK because there are the closer private and economic relations, because economic connection to Germany is only temporary. Okay, that brings us directly to the events. The job income from Hanover. Can Germany levy a tax? Because Germany is the state of non-residence, so the question regarding Germany is the first one then. Because you know, they always ask first for the source state treatment and then for the reaction of the state of residence. We suppose it might be Article 15, however, in concrete treaties, sometimes Article 15 has a different number, because as you know, Article 14 from the OECD model has been deleted, so there might be a shift in the numbers. Let's just look it up and enjoy the suspense. So indeed, we see here, it's Article 14, income from employment, subject to the provisions of Article 15, 17, 18, and 19. So if 15, 17, 18, and 19 do not say something else than wages and so on, however you call it, can only be taxed in the state of residence, that will be London, UK, unless the employment is exercised in the other contracting state, so if the job is not exercised in Hanover. However, that is the case. Now, if the employment is so exercised, then the remuneration which is derived from that can only be taxed in the other state. So the outcome here is the job in Hanover can only be taxed in Germany. However, we have to test the 183 days clause for employment additionally. But you remember, this clause does not apply if you have a job in the other state. And now our friend here has a job in Germany, so we can be sure that 15.2, the 183 days clause, does not change the situation. The right to levy a tax goes to Germany for this situation. So Article 14.1, Germany may levy tax on this job income because it is exercised in Germany. The deviation 183 days clause does not apply because there is a position in a German firm. So the next question is simply, how must UK react to avoid double taxation? And for this we probably have to look into Article 23. Now, in all probability, as the first paragraph dealt with Germans, now probably the second paragraph in Article 23. Let's have a look and find out. Yeah, indeed, Article 23, first paragraph is Germans, and we need the second paragraph dealing with UK residents, subject to the provisions, here we have it, of the law of the UK regarding the allowance of a tax credit. German tax payable under the laws of Germany and in accordance with this convention, whether directly or by deduction on profits, income, chargeable gains of sovereign and so on, shall be allowed as a credit against UK tax, computed by reference to the same profits, income, or chargeable gains by, and so on. Yeah. That's it. So UK grants a tax credit for the German job income. So UK grants tax credit for the tax paid in Germany. See Article 23, paragraph 2, DTT Germany, UK. That's it. So second event, income from royalties paid by German publishing house. What we would expect is, what may Germany do? We would expect that under Article 12 of the OECD Model Convention, there would be no right for Germany to levy any tax at all, and we would have to check if that is confirmed under the British Treaty, and naturally if it's also Article 12 or if it has been shifted to 11, 13 or what else. So let's have a look. So indeed, it's Article 12, royalties, and the basic rule is here 12.1, royalties arising in a contracting state, so royalties paid from Germany and owned by a resident of the other contracting state, so by a UK resident, shall only be taxable in the UK. And nothing else contradicts that. And we have a protocol entry to Article 10 to 12, but surprise, this is some clause on a 3-country constellation, so that doesn't affect us here. So It's Article 12.1 saying us that only the UK can tax the license fees. So Article 12.1, only UK may tax. So B, what must UK do? No obligations, as Article 23 would only apply if Germany were allowed to take a tax. So that's this case already finished, and so let's go on to the next case. And this seems to be a simple case. Not much is happening. C lives in Germany with his family, but C owns a factory as a sole proprietor in London, UK, and the profit from this factory amounted to 3 million last year. Included in this amount was, however, an amount of 1 million interest from treasury bonds, which had been contributed to the business property of the firm some years ago by C. Yeah, let's have a look. So the first thing which we can already deal with again is the residence. C is resident in Germany because he only lives there for one. That was the DTT Germany UK. We have seen that rule already several times. That's no problem. So we have only one event. That is the profit from the factory in the UK. And the first question naturally is, may the UK levy a tax? And the answer should be expected in Article 7.1 of the OECD Model Convention. At least that is what we may suspect. And we are going to check naturally if that really applies to the treaty with the UK. And surprisingly, you see here it's indeed Article 7.1, and Article 7.1 says what we always expect in Article 7.1, namely that the profits of a permanent establishment, here a factory situated in the UK, can be taxed in the UK. As we remember, there was no protocol declaration on Article 7, so that stays unchanged. The UK can levy a tax on all these profits. So UK may tax the profit, so the 3 million. How must Germany react to avoid a double taxation? That should be again in Article 23. It was paragraph 1 in Article 3, and the rest we have to find out by looking it up. You see here again, Article 23, the first paragraph relates to persons resident in Germany. The basic principle is again that if subparagraph B does not talk about a tax credit, then exemption method will be granted. And now we don't find any business profits from a permanent establishment listed under B. However, we have here a letter C, subparagraph C, which says the provisions of paragraph B, so credit method, shall apply instead of the provisions of subparagraph A to items, so parts of income as defined in Article 7, yes, our case, and to the assets from which such items income is derived, if the resident of Germany does not prove that the gross income of the permanent establishment in the business year in which the profit has been realized in the UK in the business year for which the dividends were paid was derived exclusively or almost exclusively from activities within the meaning of paragraph 1, section 8 AStG Außensteuergesetz. So What does that mean? Now it's a so-called activity clause, so that the exemption method for business profits from a permanent establishment is indeed limited to activities from business and not to additional income which is, let's say, arbitrarily shifted into the permanent establishment. Now, in our case, 1 million from treasury bonds is not an activity which comes from genuine business. It is not an activity which is regarded as active activity or active income under the rules of the German Außensteuergesetz. So it's not genuine business profit of the activities of the permanent establishment. So for this, Germany will only grant a tax credit. Yeah, let us make a note of that. So Germany exempts, but only those items of income for which the taxpayer can prove that they are derived from activities which are genuine active business activities in the sense of the German Foreign Relations or External Relations Tax Act, the Außensteuergesetz, ASDG. That is only the case for the 2 million. The 1 million from interest income are therefore only granted a tax credit for the tax levied by the UK. See Article 23(1), subparagraphs B and C. And also that case is then finished, all over and done with, and that's nice. So I hope that was enough practice for today. Thank you very much for watching. Don't forget to recommend the channel, press a like button, and the most important thing of all, come back soon. Thanks and goodbye.